Hi there, Andrew Reed here, NCA Exam Study Guide, looking at part 6 of this series, looking into criminal law. Now this study guide is just following along with the 2023 NCA exam constitutional law syllabus, doing case briefs on the hyperlinks, and a few other notes. Okay, let's go ahead and get started with part 6, criminal law. So there is a reference to Section 91 of the Constitution, subsection 28, the criminal law, except the Constitution or of courts of criminal jurisdiction are within the powers of Parliament, including criminal procedure. And the first case on this list that I have briefed is the reference re-validity of Section 5 of the Dairy Industry Act. And so a little bit of background here. The subsection A of the Section 5 Dairy Industry Act provides that no person shall manufacture, import into Canada, offer, sell, or have in his possession for sale any oleo, margarine, butter, or other substitute for butter manufactured wholly or in part from any fat other than that of milk or cream. So that was a federal law that was put in place. And then the issue became whether this Section 5A of the Dairy Industry Act was ultra vires parliament, as in not constitutional. Okay, so rule here. Parliament cannot acquire jurisdiction to deal in the sweeping way in which these enactments operate with such local and provincial matters by legislating at the same time respecting external interprovincial trade and committing the regulation of external interprovincial trade and the regulation of trade which is exclusively local, and of traders and producers engaged in trade which is exclusively local to the same authority. Natural products marketing case, basically saying that the federal government can't get into the nitty-gritty details of trade and regulating trade just because there's components of local trade that are embedded into external and interprovincial trade. Okay, a little bit complicated, but the analysis helps clear that up a bit. The conclusion, the prohibition of the importation of the goods mentioned in the section is constitutional, but the prohibition of manufacture, possession, and sale is not constitutional for Parliament to make that law. Okay, there was some dissenting opinions here that are worth mentioning. The prohibition of manufacture, offer, sale, or possession for the sale of the goods mentioned is unconstitutional, according to the dissent. It is legislation in relation to property and civil rights, which is a provincial right, which cannot be supported under any head of Section 91, nor can it be supported as legislation for POG. Okay, so they're pro-province there. And they also say there's no ground on which it may be held that the legislation here is not an enactment creating a criminal offense in exercise of the powers vested in Parliament by Section 27, subsection 27 is Section 91, which is the criminal law empowerment. So some of the analysis from the majority here. The purpose of a legislative enactment is generally evidential of its true nature or subject matter. So they ask, is the prohibition then enacted with a view to a public purpose which can support it as being in relation to criminal law? Public peace, order, security, health, morality. These are the ordinary, though not exclusive ends served by that law. But they do not appear to be the object of the parliamentary action here, the court says. That object, as I must find it, is economic. And the legislative purpose is to give trade protection to the dairy industry in the production and sale of butter. So to benefit one group of persons as against competitors in business, in which, in the absence of this law, the latter would be free to engage in the provinces. So to forbid manufacture and sale for such an end is prima facie to deal directly with the civil rights of individuals in relation to particular trade within the province. And they quote this from Shannon versus Lower Mainland Dairy Board. Okay, they go on in the analysis to say the public interest in this regulation lies obviously in the trade effects. It is annexed to the legislative subject matter and follows that subject matter in its allocation to the one or other legislator. But to use it as a support for the legislation in the aspect of criminal law means that the country under its authority in that field, by forbidding the manufacture or sale of particular products, could, in what it considered sound trade policy, actually impact a substantial part of the economic life of one section of Canada, but do it for the benefit of a different section of Canada. So whatever the scope of the regulation of interprovincial trade, it's hard to conceive a more insidious or bad form of encroachment on a complementary jurisdiction. There's nothing of a general or injurious nature to be abolished or criminal. It's a matter of preferring certain local trade to others, which is why they're saying here that that it's partially unconstitutional. Okay, so that case is a little bit confusing, but there apparently is a series of dairy cases in Canada dealing with that particular subject, and so be wary of the interaction between trade and commerce, POG, and criminal law, because there seems to be quite the interweaving there. Okay, next case on this one, quite a bit more understandable. The Reference-Free Firearms Act of Canada 2000. So background, in 1995, Parliament amended the Criminal Code by enacting the Firearms Act. The amendments required the holders of all firearms to register their guns. Now, Alberta wanted to know whether the licensing and registration provisions of this act were constitutional. The majority of the Court of Appeals said that this was a valid exercise of the Parliament's criminal law power, and Alberta appealed this and got shut down. So the Supreme Court held this registration of all firearms to be constitutional. The issue, whether the registration provisions of this Firearms Act were constitutional, and the rule came, and they say it's constitutional because it is criminal law, and criminal law has to have a valid criminal law purpose backed by a prohibition and a penalty. R.J.R. MacDonald. So really clear rule right here as to what classifies a criminal law. So the analysis as to why this was criminal law. So they say, yes, it was criminal, that's why it's constitutional. The act in its pith and substance, remember that primary analysis, is directed to enhancing public safety by controlling access to firearms. Its purpose is to deter the misuse of firearms, control those given access to guns, control specific types of weapons. It's aimed at a number of mischiefs, including the illegal trade in guns. The purpose of the act conforms with historical public safety focus of all gun control laws, and the changes introduced represent a limited expansion of pre-existing gun control legislation. The effects of the act also suggest its essence is the promotion of public safety, and so on, saying that all this is normal and just a minor expansion, even though everyone now had to register all guns. But this was legislation created by the party that was voted in, and the court doesn't really go in there and tell them whether they're being smart or not. That's not at stake here. It's whether it's constitutional. The Firearms Act possesses all three criteria required for a criminal law, and is therefore constitutional according to the court. So, gun control has traditionally been considered valid criminal law because guns are dangerous and pose a risk to public safety. The regulation of guns as dangerous products is a valid purpose within the criminal law power. That purpose is connected to prohibitions backed by penalties, and these are not regulatory penalties, like you can go to prison for breaking them. They're not little fines. They are not confined to ensuring compliance with a scheme, but independently serve the purpose of public safety. Parliament's intention was not to regulate property, but to ensure that only those who prove themselves qualified to hold a license are permitted to possess firearms of any sort. Finally, Parliament can use indirect means to further the end of public safety. So, while ordinary guns are used for lawful purposes, they're also used for crime and suicide. Again, saying this is okay to be criminal law. So the registration provisions cannot be severed from the rest of the act. So the licensing and registration, all this needs to be in there, and both are tightly linked to the goal of promoting safety. It does not entrench on provincial powers, such that holding it as criminal law will upset the balance of federalism. The province were not able in court to establish that the effects on the act on the provincial jurisdiction over property and civil rights are more than incidental. The mere fact that guns are property does not suffice to show that a gun control law is in pith and substance a provincial matter. Second, the act does not significantly hinder the ability of the provinces to regulate the property and civil rights aspects of the guns, And third, assuming that the provincial legislators have the jurisdiction to enact a law in relation to property aspects of firearms, the double aspect doctrine permits Parliament to address the safety aspects of firearms. Fourth, the Firearms Act does not precipitate the federal government's entry into a new field, since gun control has been the subject of federal law since the Confederation. And there is no colorable intrusion into provincial jurisdiction. More on colorable later. So the problems associated with the misuse of firearms are firmly grounded in morality. However, even if gun control did not involve morality, it could still fall under the federal criminal law power. Parliament can use the criminal law to prohibit activities which have little relation to public morality. The apprehensions of Northern, rural, and Aboriginal Canadians that the law does not address their particular needs doesn't go to the question of whether Parliament had the jurisdiction to enact this law. The cost of the program, the efficacy of the law, the effects of it, or lack thereof, are all equally irrelevant to Parliament's ability to enact it under the division of powers analysis. So within its constitutional sphere, Parliament is the judge of whether a measure they make is likely to achieve its intended purpose. Some notes here: where the effects of the law diverge substantially from the stated aim, colorable. And also, the presumption of constitutionality means that the party challenging the legislation is required to show that the act does not fall within the jurisdiction of Parliament. It's from Nova Scotia Board of Censors versus McNeil. So again, if someone says this is not constitutional, they have to prove it because there's a presumption of constitutionality. Final case on the syllabus under criminal law, reference re Genetic Non-Discrimination Act. This is 2020, the most recent on the list. And this is just asking the same kind of thing, whether subsections 1 to 7 of a Genetic Non-Discrimination Act were unconstitutional. And as we already know, Section 91, subsection 27, that head of power of the Constitution Act, gives Parliament the exclusive authority to make laws in relation to the criminal law. A law will be valid criminal law if, in pith and substance, it 1. consists of a prohibition, 2. is accompanied by a penalty, and 3. is backed by a criminal law purpose. And this law was considered constitutional. The pith and substance of the challenge provisions is to protect individuals' control over their detailed personal information disclosed by genetic tests. So Canadians were scared, or at least that their genetic test results would be used against them, and they wanted to avoid discrimination. But this matter is still properly classified within Parliament's power of criminal law, because these provisions are supported by a criminal law purpose, according to the court, because they respond to a threat of harm to several overlapping public interests traditionally protected by the criminal law: autonomy, privacy, equality, and public health. So the dissent did not agree, as typical dissents will not agree. Sections 1 to 7 of the Act were not enacted within the constitutional authority of Parliament over the criminal law under Section 91, subsection 27 of the Constitution Act. Rather, they fall within provincial jurisdiction over property and civil rights, in other words, contracts. Property and contracts conferred by Section 92(13), which is the list of provincial heads of power. The pith and substance of subsection 1 through 7 is to regulate contracts and the provision of goods and services. This is the dissent continuing. In particular, contracts of insurance and employment, by prohibiting perceived misuses. So in that case, sections 1 to 7 do not satisfy the substantive component of criminal law, which is a valid criminal law purpose, because Parliament didn't articulate a well-defined threat that it intended to target, nor did it provide any evidence of a foundation of such a threat. Instead, these subsections substantially affect the substantive law of insurance, as well as human rights and labor legislation in all provinces, which those specific things would traditionally fall under 92(13), property and civil rights. So that's where the dissent is going with that. All in all, these are some interesting cases as to how constitutional law helps shape criminal law. And that'll conclude this part of the study guide. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.